Hi, I'm Philip Hundl. I'm an attorney with Wadler, Perches, Hundl, and Kerlick. I'm here with another lawyer at Wadler, Perches, Hundl, and Kerlick, Shay Krauscraw. Shay is going to talk today about some top tips for business owners regarding collection matters.
Okay, as Philip said, I'm an associate attorney with Wadler, Perches, Hundl, and Kerlick, and I'm here to really address this video to small business owners. And I want to talk about just a quick list of 3 things you can do to protect your rights as a creditor. So let's say that you've done a project for a larger company or a smaller company, and you have failed to be paid for that project. The best way to protect yourself is by recording what we call an M&M lien. This actually stands for a mechanics and materialmen's lien. Basically, the most important thing in this realm is keeping track of your timeline. The M&M lien statute requires very strict notice provisions. Depending on whether you're a general contractor, subcontractor, or even a sub-subcontractor, this notice provision is generally 2 to 3 months after each month in which you performed labor. So the beauty of an M&M lien is if it's properly recorded, you can actually file a lawsuit to foreclose on that lien. And this is an excellent way to protect your rights as a creditor. Foreclosing on the project will allow you to satisfy your judgment. Another great way to protect your rights as a creditor is by, before actually performing any work, have the contractor that you're contracted with sign a credit application. Generally, a well-written credit application will have a personal guarantee on it. This personal guarantee will also not only put the entity itself on hook, but then the person that signed the personal guarantee will be liable for the debt as well. So it's just a good way to kind of bring another party into the lawsuit and put some pressure on people, etc. Finally, another great way to protect your rights as a creditor is by just contacting an attorney. Whenever you contact an attorney, he or she will first do a lien evaluation. If the lien is still available, he or she will help you record the lien, or maybe just record it on their own. If a lien is unfortunately unavailable, the attorney will start by sending a demand letter. This demand letter just simply demands payment and additional attorney's fees that you may have accrued. If an attorney has to do all these steps and unfortunately doesn't hear from anybody, then he or she will file a lawsuit seeking a judgment. And if a judgment is awarded, he or she can then try to collect on that judgment by seizing assets, or there's a number of different ways. So please remember that when you contact an attorney, it's important that you have together all of your sent invoices or accounts receivable reports. And it's also helpful to provide a little bit of information about the debtor as well. So like I said, these are the top 3 ways in which you can protect yourself as a creditor. Thank you for watching.